Welcome everybody into the space. My name is Rachel Bryce, and I'm the Program and Development Manager with Land for Good. And for any of you who might not be familiar with our work, we've been around since 2004. We work in all 6 New England states. Our mission is to expand secure farmland access, tenure, and transfer. And today we have the privilege of hearing from attorney and Land for Good board member Allison Poirier. She's here to speak with us about planned giving. We have set the session up so there should be time for questions and answers at the end. If anything comes up that you need immediate attention, feel free to pop something into the chat. I'll be monitoring that. And again, thanks so much for joining us, and I'll turn it over to Allison.
Great. Well, thank you, Rachel. I've been on the Land for Good Board of Directors for just under a year, but I've had the privilege to work with the organization for many years prior, so I'm very happy to be a part of the board. I'm very happy to be presenting today to talk about planned giving because my background as an attorney is really based in estate planning, estate administration, elder law, so planned giving is a topic that I deal with a lot on a daily basis. So for purposes of kind of starting right at the beginning, and maybe just as a kind of a brief disclaimer, I do practice in Connecticut. So if I'm quoting laws and things of that nature, I'll try to point out when it's Connecticut specific with the understanding of there might be some variations from state to state. But to get started, so what is planned giving? It's one of these terms probably a lot of people have heard, but maybe never gotten a solid definition. What do you mean? So planned giving is really just the process of making a charitable contribution to one or more charitable organizations as part of your financial or estate plan. A lot of times, kind of the most frequent way that we see this set up is to have large gifts or large bequests made to charities at certain points during your lifetime or upon death. But it can also be smaller amounts periodically, kind of like regularly over the course of the year or over your lifetime as well. And there's multiple benefits for doing planned giving. One, and I think is the most obvious, is you get to support really great charitable organizations. So you can either make, again, these recurring distributions or recurring donations over the course of your lifetime that helps fund those annual budgets, help support their missions, or these larger distributions, again, either upon death or during your lifetime that can potentially fund bigger projects and things of that nature. But it's all in the name of supporting a really good cause. Selfishly, you also do get various tax benefits for making these charitable distributions as well. So there's personal benefit there on the donor's end. And also by setting this up maybe as a larger donation, even through your estate plan to say, well, it's really only going to occur after I pass away. It opens some doors in terms of a lot of people maybe can't afford to make really big distributions during their lifetime. But after you pass away, there's an ability to maybe set aside a larger chunk of your estate or to your assets to have a larger, more lasting impact for the charity. Right. So our next slide here. So again, kind of several different ways that you can do planned giving. And I've referenced a couple of them, but as part of an estate plan, a lot of times we're seeing these types of plans for giving set up through the actual legal documents. So it's under your will or it's under some form of a trust that you set up. And I'll get into a little bit more detail maybe in terms of the types of trusts and kind of the way you can set those up. But another way that we see is also very common is to name a charity directly as a beneficiary on one or more of your accounts. So you can kind of bypass all the legal documents and just say, when I pass away, the money goes to, these charities in equal shares. So that's another way you can accomplish that giving as well. All right, so starting with the legal documents, and maybe just to provide a little bit of kind of estate planning basics so you understand how these documents work, which would mean how the bequests are ultimately going to be made pursuant to these documents. So if you have a will, the whole purpose of a will is to direct how assets that are passing through your probate estate are supposed to be distributed upon your death. Keeping in mind that 100% of your assets are not going to be passing through probate. Only certain types of assets go through probate and are therefore only certain assets are going to be distributed under your will. And again, I'll say specifically in Connecticut, albeit I understand this is pretty much the case for most other states I've bumped into. The only assets that have to go through probate upon your passing are assets that are owned directly in your name that do not have a beneficiary. So if I have a checking or a savings account that's solely in my name with no beneficiary on it, that would go through probate. If I'm the sole owner for my house when I pass away, that would go through probate. But other types of assets, like assets that are owned jointly, don't go through probate. So if I own my house and my checking and savings account jointly with my husband, when I pass away, those instead bypass the will, bypass probate, instead would go directly to him. Additionally, assets that are passing through a beneficiary designation also get to bypass probate and instead just go directly to the beneficiaries you've named on those beneficiary designation forms. And so I always find it's important to kind of make that distinction of what assets are going through probate or not, because sometimes you see folks set up a will to say, okay, under my will, when I pass away, I'm leaving a certain chunk of money to Land for Good or to these charities of my choosing. But the way that they own their assets is such that none of their assets end up passing through their will when they pass away because they're actually owned jointly or they're actually passing through a beneficiary designation. So creating a will is kind of only half of the estate planning process. The other piece is taking a look at how you actually own your assets to make sure if you say under your will, well, I want Land for Good to get $10,000 when I die, you have to make sure there's actually assets passing under your will in order to fund that bequest. So that's wills are one way then to make those bequests. So when I die, X amount of dollars or so go to the named charities. You can also use trusts, as I've mentioned. The most common type of trust that we use in the estate planning context is known as a revocable trust or a living trust, with the number one objective being that people want assets, still want the assets to get to the folks they want to receive them, but they just don't want to have the assets go through probate. So to the extent you have your assets not owned directly by you, but instead owned by a trust, that's a way to have the assets still get to, again, those same people, but now we just don't need probate court involvement, so it's less administration, and the distributions get to happen a lot quicker. So whether you're using a will, whether you're using a trust, there's kind of two methods for how you want to name charity or how you can name charities as receiving beneficiaries as part of your planned giving program. So you can either say, I give a flat dollar amount. So in my example here, I say, I give Land for Good $10,000. Or another way to do it is to leave instead a percentage. So when I pass away, 10% of my estate goes to Land for Good. Being an estate planning attorney, I tend to err more on the side of the percentage route, just because we never know what's going to happen. I never know exactly how many dollars I'm going to have when I pass away, because when I set up my plan now, my assets might be different 15, 20 years later when I actually pass away. So if I leave a flat dollar amount and I may not have sufficient funds to fulfill the bequest or my assets have somehow changed, that may impact how that bequest is going to be fulfilled to the charity. But a percent is always a percent. So whether I have $1 million or whether I have $100,000, 10% is always going to be 10%. So a lot of times when setting up folks' estate plans, unless we know absolutely for sure we're going to have sufficient money to fulfill a flat dollar amount bequest, if we don't know that to be the case, then I say maybe it's safer just to lean on the side of, let's just say, then a certain percentage of the estate. All right. So there are a couple different types of trusts that I mentioned, and I did reference that probably the most common one that we see and kind of more straightforward estate planning is a revocable trust. Because the revocable trust, as I hinted at before, the number one objective with those types of trusts are, I just want to keep my assets out of probate when I pass away, but I want to still retain full control and access to those assets during my lifetime. So what I can do is I can set up a revocable trust and I put my house into it. And then if I want to sell my house or I want to move things around, I still can because I'm still in control. But when I pass away, the court is going to say, the probate court is going to say, I didn't own my house. My trust owned my house, even though really it was still me. But it's kind of enough of a tweak of ownership interest, way the property is owned or that asset in trust is owned, such that it just doesn't have to go through probate. And maybe kind of to back up, there's kind of, I think that to shed a little bit light on how these trusts work, there's kind of three groups of people that you're always going to want to know about in the context of a trust. The first is the settlor, or sometimes also called the donor or the grantor, and that's the person who's setting up the trust. So pretty much that's you. As part of your plan, you're creating this trust, you're the settlor of your trust. The second person is the trustee. And the trustee is the person in charge of implementing the rules that you've included in your trust. So the trust is always going to have rules to say, well, if there's assets in the trust during my lifetime, here's what the trustee is allowed to do. Or after I pass away, assets have to go to a certain place. But in the meantime, maybe there's distributions that need to be made. Maybe there's tax returns that need to get filed. There's certain kind of administrative things that might need to be done. And so that's the trustee's job, is simply just to implement the rules that you've written. The third person in the trust is the beneficiary. This is the person who the trust is intended to benefit and who is actually entitled to receive distributions from the trust. So with that understanding, now going back to kind of a more straightforward revocable trust, again, that's a very common estate planning document. You are the settlor of your trust. You're the trustee of the trust usually, and you're also the beneficiary of the trust. So that's why I said kind of with these revocable trusts, it's really kind of this legal fiction that we've transferred your assets anywhere that you don't own them and to say that the trust owns them because you really are your trust. So that's what gives you the right to still retain all that control over the assets during your lifetime, but then just simply say, but when I pass away, here's where it goes. But it just now doesn't require that court involvement to make those distributions. So under that type of revocable trust planning, it's going to say during my lifetime, really, I'm the primary beneficiary. And then upon my death, now it's, 20% goes to land for good. The balance goes to my kids, however you want to set that up. So it functions the exact same way as the will, but again, just less administration. With irrevocable trust, those are more used in terms of asset protection planning. So if I was concerned that I'm in a high risk profession, I'm a lawyer, I could get sued and I could end up all my assets going to, lawsuit creditors. I might need long-term care when I get older. So all of my funds and all of my assets might have to go towards caregivers and nursing homes. So basically, it's a situation where I might be concerned that I might lose most or all of my money due to these other types of creditors out there. And I want to protect those assets to make sure there actually is something left to leave behind to those charities that I want to support or to my family, whomever those intended beneficiaries are. That's where more irrevocable trust planning comes in. I can say, I'm going to set up my irrevocable trust. I'm going to put my house or my investments, whatever it is, whatever asset it is that I'm looking to protect into the irrevocable trust. With that irrevocable trust, I'm still the settlor because I still created the trust, but typically I'm not the trustee. I'm not the beneficiary. We do really want a loss of control there because if you're not able to kind of reach out or touch those assets, then neither can your creditors. So that's where the protection is going to kick in. So in a planned giving context, what I can do is to say, well, I might need all my money to pay for my long-term care costs. I'll just focus on that because that tends to be a really common concern. I want to protect my assets from all just having to go to long-term care. I still want to be able to protect my money, but I don't really need my house necessarily in terms of I need to be able to live in it. But legally speaking, we can transfer ownership of the house maybe to this trust, still let you live there, but you just won't be the deemed owner, so we can get some protection there. So you say, even if I have to spend all my money then on long-term care or other costs during my lifetime, I know I've protected my house. And then once I pass away, same thing, my trust terminates. And I say at that point, my house gets sold and 10% goes to land for good and the balance goes to my kids, however you want to set that up. So if it's not only to say that, man, I'd really like to leave money behind for charities, but to say, wow, I might have some other expenses where I may not have anything left to donate to charity. And I want to make absolutely sure I still can make those bequests when I pass away. So I want to really protect my assets. That's why when we're talking about planned giving, it might not just be, let's talk about revocable trust, but we might also talk about irrevocable trust. And again, it just depends what your primary concerns are. All right, so the third option I mentioned is you can also name a beneficiary, or excuse me, a charity as a direct beneficiary on one or more of your financial accounts. And it works with pretty much any type of financial account that you have. And I've listed off some of the most common ones here: life insurance policies, retirement accounts, investment accounts. You can fill out those forms directly with the financial institution that's holding those accounts or holding that policy to say, when I pass away, here's where the money goes to. And it can be, I leave everything to my spouse first, but if we're both gone, then it goes to land for good, something like that. And I do recommend when you're filling out beneficiary designations, just at all times, you should not only have a primary beneficiary, but also a contingent beneficiary, so a secondary beneficiary on there. So if you say, well, I'd like to leave money behind for the charity, but really it's only upon, and just because I do a lot of planning with married couples. It's really only upon the second one of us to pass away, that's when the money would then go to the charity. And so that's when you would set it up to say, well, my primary beneficiary is my spouse, but Land for Good is the contingent beneficiary on those accounts. And as I mentioned, one of the upsides to doing a beneficiary designation is those assets also get to bypass probate. So with an eye towards, again, simpler administration, keeping more things out of that probate process, which just makes everybody's life a little bit easier. You're going to get that probate avoidance by filling out those beneficiary designation forms. And there's particular tax benefits specifically as to retirement accounts when those assets pass to a charity. Specifically 401ks, IRAs. Those are all what we call qualified retirement accounts, or another way to describe them is kind of pre-income tax dollars. The way these accounts are funded, as everybody's probably pretty well aware, if you have a 401k that you've set up with your employer, every paycheck, money just comes off the top of your paycheck, goes directly into that account, and you never pay income taxes on it. With the idea being the government's trying to help you save towards retirement. And so while you're working, money goes in, money goes in, money goes in. And then when you hit retirement age, you start withdrawing money from those accounts. That's when all of a sudden you pay the income taxes on those funds. It's finally when you actually take them out of the account. So when you take money out of your account, you pay income taxes on it. Same rules are going to apply to say if I pass away and I have money still left in my IRA and I say it goes to my kids, when they start pulling money out, they have to pay income taxes. At some point, somebody's got to pay the income taxes on those money because the government wants their taxes. The benefit to saying, well, instead of maybe leaving that IRA when I pass away to my kids, I'm going to leave that directly to Land for Good, because by leaving those qualified accounts directly to a charity, charities don't have to pay income taxes. So they get to keep 100% of those dollars. So it really allows more of your money to stay in their hands and go towards their charitable purposes. So, hey, whenever you can avoid paying taxes, why not? So it's not only a benefit to, I mean, yes, you get to make a normal charitable contribution, but it's also avoiding that tax blow. So it's really more of your money gets to go towards that charitable cause and help them with the mission that they're help them with their mission, like Land for Good and preserving farmland and connecting farmers with access to land and all the wonderful things that they do. So another way to do this too, also with an eye towards kind of staying on this topic of qualified retirement accounts. As I mentioned, when you hit retirement age, you have to start pulling money out of those accounts. Under current tax laws, the absolute latest you can wait to start taking distributions from those accounts are what's called your RMD. Every year, there's going to be a required minimum distribution once you hit a certain age. That's that RMD. The absolute latest you can wait to start taking those RMDs is age 73. So some of my clients are in the position where they say, well, I have assets that's sufficient. I'm already getting Social Security, I'm getting a pension from the estate, or I have other savings. I'm required to take this distribution every single year out of my retirement account. I have to take a tax hit, but I don't really need the money. I mean, ideally, if I could have just let it sit there, I would have let it stay there. I didn't need to take it out, but because the IRS rules say I have to, I just had to take it out. So when you take out that RMD, you're going to get your 1099 at the end of the year saying you've made a withdrawal from those retirement accounts. You now all of a sudden have to pay the income taxes. Well, if you say, again, I need to take this RMD, but I don't really need the funds, you can also do what's called a qualified charitable distribution, where the RMD is going to come out, but instead of coming to you, you can designate a charity that it'll just go directly to the charity. It never even hits your hands, just goes right to the charity. Again, that's going to mean that the charity gets those funds and doesn't have to pay income taxes on it. So more of your dollars going towards supporting that charitable organization. It satisfies your requirement to take out the RMD because the money did come out. So that's why it's kind of a win-win for everybody. You didn't have to pay the taxes. You still get to make your charitable contribution. The only catch is that you have to be over age, and I'm not sure why they specifically chose this age, but under current tax laws, you have to be over the age of 70 and a half in order to make these qualified charitable distributions. So just keeping that in mind, that if that's a technique that works for you to say, well, maybe that's the pool of money that I'm making my annual charitable contributions from, there's tax benefits to doing that both for you and for the organization you're contributing to. Another option for lifetime gifts is through use of what's called a donor advised fund. And essentially, in kind of its simplest terms, what you can do, what a donor advised fund is say, I have this chunk of money that I want to donate to charities. But it's not that I necessarily all want to go out directly to the charities this year. So just to pick a hypothetical amount, I have $50,000 sitting in this account that I know I want to go towards charitable purposes, but maybe not all go out this year. I haven't fully decided which combination of charities I want to support. But you can take that full 50,000, put it into this charitable account, this donor advised fund. And it's now deemed to be a completed gift as far as the IRS is concerned. So you no longer own those funds. And then there's the financial institution is kind of managing those funds for you. And then every year, every however often you're making contributions, you can say, okay, if you're doing it on an annual basis, okay, this year, $1,000 is going out here, $10,000 is going to Land for Good. Even though you don't own the money, you still get to direct how it's being distributed each year. So that's why if we're looking at kind of, again, with an eye more towards that asset protection piece as well, this gets the money fully out of your hands. So if you wanted to make absolutely sure there's going to be money in order to gift to charities, this a donor advised fund is one way to do it. Again, because legally it's out of your hands, but you still have these kind of some strings, enough strings attached where you can direct how the money is distributed during your lifetime. And it also gives you the ability to say, and then when I pass away, here's where the money goes then. So you still kind of, both as an estate planning, after I pass away, you direct where the money goes, but you also get to direct where it goes during your lifetime. With a transfer to a donor advised fund, as I mentioned, the money doesn't go directly to the charity all at the time it leaves your account. It goes and sits in that account and kind of usually gets distributed over time to the charities of your choice. But in the year you make that distribution, in the year you make that gift of the money to the donor advised fund, you get an income tax deduction for the full amount that you've gifted to that donor advised fund. So in my example where I said, I have this $50,000 that I want to go to the donor advised fund, I have, and again, not to say I can necessarily claim it all in one year because there's restrictions on the amount of the charitable charitable deduction you can get on your tax returns, but I get credit for making a $50,000 charitable contribution in the year that money leaves my accounts. So again, really big tax break for those folks who want to go the donor advised fund route as well. So I've started to hit more on some of those tax benefits or kind of the what you get with income taxes for making charitable contributions. Maybe before I get too far into the tax piece of it, I'm going to give you what the rules are currently for 2025. But there was a bill that recently got passed, the One Big Beautiful Bill that maybe some folks have heard of, that did make some changes to tax laws specifically as to charitable contributions. So I'm going to let you know what the rules are for 2025, because if you're still going to be making charitable contributions this year or through the end of the year, these rules will still apply when you're filing your returns at the beginning of next year. But 2026 going forward, there's been some changes in those rules, and I'll try to highlight what some of those changes are as well. But for 2025, you can deduct charitable contributions that you make over the course of the year to offset income. So again, tax benefit to you for making those charitable contributions. If you make cash contributions right now in our current tax laws, you can deduct, or actually maybe I'll back up to say, first of all, you have to itemize your deductions on your personal income tax returns to really get the biggest benefit to charitable contributions. So if you're just claiming the standard deduction, you don't get all these different charitable deductions because you've just got that standard deduction. That's kind of it. But if you itemize your deductions, that's where these next rules come into place. So again, for cash contributions, you can deduct up to 60% of your adjusted gross income. And a lot of these tax terms tend to get fairly complicated, but generally speaking, your adjusted gross income is the money you bring every year, and there's certain kind of what this the IRS calls above the line deductions that they kind of take right off the top. Certain examples include student loan interest payments, HSA contributions, alimony payments. For certain things, they kind of just take those right off the top and they say that's not really part of your income. And once they take off those, that short list of kind of above the line deductions, you're left with your adjusted gross income. Once we have your adjusted gross income, again, you can deduct up to 60% of that with charitable contributions. So since I was an English major, I like to use nice round numbers. So if my adjusted gross income was $100,000 and I made $70,000 worth of charitable contributions, I can deduct 60,000 of that off my income. So I don't get the full extent of it, but I can deduct up to 50%, or excuse me, 60%. For non-cash contributions, I inherited a piece of land from my grandparents up in rural Vermont, and I say, well, you know what? I'm really not using this land. Wouldn't it be great to give it to Land for Good? So I can donate the land to them, but because it's a non-cash contribution, for that in terms of the tax deduction, I would only get to deduct up to 30% of my adjusted gross income. But even if I can't deduct the full amount of my charitable contributions in any given year, the IRS allows you to carry them forward. So in my first example where I said I have a $100,000 AGI, I made a $70,000 contribution this year, I can only deduct up to 60,000 of it. So there's $10,000 that I didn't get to use this year because I maxed out. But I can carry that forward next year. So next year I can still get that additional 10,000 and deduct it off my next year's taxes. And depending on the amount of the gift, you can carry it forward, that overage, up to 5 years. So even though you may be limited in one particular year, in the year you're making the gift, again, you can carry those gifts forward or those contributions forward and continue to get those tax benefits. So those are the current rules under 2025. With 2026, as I mentioned, there's that one big beautiful bill that made some changes in the tax laws. One of the biggest changes as it relates to charitable contributions is that you can get a charitable deduction even if you don't itemize. So you can claim your standard deduction, and on top of that, you can still get, if you're single, you can get an additional up to $1,000 charitable deduction on top of the standard deduction. If you're married filing jointly, it's kind of each person has their own 1,000, so total you get an additional $2,000 charitable deduction. So that was kind of a nice add-on that they included to say, I don't want to go through the hassle of itemizing all my deductions, but I know I make gifts to charities this year. So you get kind of the best of both worlds. For higher income donors, people who are making really large charitable contributions over the course of the year. I'm not going to get too far into the specifics of the changes there, but suffice to say that the government implemented new rules that essentially put caps on the amount of the deduction that you're allowed to get when it comes to charitable contributions. It's based off of the income tax bracket that you're in. It's based off of your AGI, so all those things factor in. So I would say if you have really specific questions about, well, I'm not sure if those new rules or new caps are going to apply to me. I'll also admit I'm by no means an accountant, so I would highly recommend chatting with your accountant to see what those changes are. But what a lot of folks are saying if you are saying for 2025, if you do still want to make kind of larger charitable contributions and get the benefits of all the tax rules, again, that we currently have in place, because we know there's going to be caps now and kind of ceilings going forward in 2026, maybe you give a little bit more in 2025 while those ceilings aren't in place. So again, you get a little bit more bang for your buck in making those larger charitable contributions in this year before the tax laws change. With taxes, we've talked about really the income tax benefits that you're going to get during your lifetime for making charitable contributions, but there may be also some tax benefits you're going to get after passing. So, and it's all in the estate context. So to start with the estate tax, there is a federal estate tax, and a lot of states individually have state estate tax. Connecticut is one of them. And basically, how a state tax system works is to say if you own over a certain amount of assets at the time you pass away, then the state is going to tax you. And that's after you pass away, the executor of your estate is going to file an income tax return to say, here's all the assets that you have. And then the state or the federal government determines is there a tax due. Currently, right now in 2025, the estate tax exemption amount, or the amount of assets you would have to exceed in order for a tax to be due, is $13.99 million. I'm not sure why they chose 13.99 instead of just saying 14, but it's 13.99. So if you have over $13.99 million and you pass away in 2025, there's going to be an estate tax due. In 2026, because that federal estate tax exemption is indexed to increase with inflation, it is going up to $15 million. So I'm not going to sit here and tell you you're going to have an estate tax problem because, quite frankly, most people won't just because the exemption amounts are so high. And also for married couples, keeping in mind that each person has their own $13.99 million exemption in 2025, or each person has their own $15 million exemption in 2026. So for a married couple, if one of you passed away in 2026, you would really have to have over $30 million for there to be any kind of taxes due. So also keeping that in mind. But that being said, if you're one of the lucky few that has a potential estate tax problem, there is a charitable deduction on the estate tax return that could minimize or eliminate those estate taxes. So keep that in mind. Probably more pertinent, more relevant to more folks is the state estate tax. Most state estate tax have a much lower exemption amount than the federal. Connecticut, actually, we like our exemption amount because we said a few years back we were just going to match the federal. So Connecticut's exemption currently is the same as the federal. So we have a very high state tax exemption amount, which still means most people aren't paying estate taxes. But other states in New England have much lower estate tax exemptions. To give you an example, in Massachusetts, the current estate tax exemption for 2025, and it looks like it's going to stay the same in 2026, is only $2 million. In Vermont, it's $5 million. In Rhode Island, I think it's around $1.2 million. So just keeping in mind, even though most people unfortunately will not pay a federal estate tax, if you have a state with a lower state estate tax exemption amount, you may still have to pay an estate tax just at the state level. So these charitable deductions, while not relevant at the federal level, might become a whole heck of a lot more relevant at the state estate tax level. So keeping that in mind. Also, just to throw out there too, there are some states that don't have a state estate tax. I know New Hampshire is one of them. Florida is one of them. So just look at the tax laws in your state. But if you do live in a state or do live in a state with a lower estate tax exemption amount, you might want to take that into account when you're planning charitable distributions either during the year or again through your estate plan. Also, with an estate, if anybody's been through probate or seen estates administered, you know it can be a fairly lengthy process depending on the amount of assets or the type of assets that the estate contains. So it's also possible an estate may have to pay income taxes too. So most estates in Connecticut that are going through the probate court system on average take about a year from start to finish. So over the course of a year, there may be certain assets in the estate that are generating interest, dividends, if you have a large stock portfolio, for example. So there may be things that the estate itself now that you've passed away, the estate becomes the taxpayer. So the estate may be having to pay income taxes on these assets that are in the estate before they're distributed out to the beneficiaries. So if that's a concern, there's also a charitable income tax deduction for estates to say that, okay, under the will, under the trust, it says X amount of dollars, $10,000 are supposed to go to Land for Good. We had to take an RMD from an IRA that was in the estate that kicked off all these taxes and income now that we have to pay taxes on. So to offset that, the charitable bequest in the will, again, is now a deduction to offset that income. So not only is there a potential benefit at the estate tax level, which again, depending on your state, may or not be a concern, but it may be a bigger benefit to say, well, if I'm not worried about estate taxes, but I'm worried about estate income taxes, again, there's still that benefit to making that charitable contribution to keeping those charities included as part of your estate plan to offset any income taxes that might be paid at the estate level. All right. And also, too, I know I focused a lot on kind of really high income tax deductions you can get for people making large contributions or people who are owing millions of dollars worth of estate taxes and such like that. But you don't have to be a millionaire, as I'm sure comes to kind of no surprise to everybody. You can make charitable contributions at any point, at any amount. So don't feel like, oh, well, I'm maybe not in a position to set up some kind of planned giving or to make charitable contributions as part of my plan, just because I don't have enough to warrant, making those types of contributions or doing that type of planning. It can be as simple as going on to, the Land for Good website. They have that big green button up at the top that says donate now. You can click on that and say, you know what, I'm just going to donate $50 a month. So that's something that's easy enough for me that where it's not going to impact my income every month, but I still get to make that distribution. And over the course of the year, those smaller contributions can really add up. Also, too, with making kind of those regular recurring gifts, it helps the charities kind of set their budget. I know we have these recurring gifts that are going on for this year, so I know we're going to be able to fund this project. I know we're going to be able to fund a salary for an employee to continue to do all this good work that we're doing. So I'm always kind of taken aback, or I get up a little bit on my soapbox when people say, oh, estate planning and planned giving, that's not for me. I don't have enough money. I don't have enough money to do charitable giving. Because everybody always thinks about, in the movies and in these books where people would just receive these, huge inheritances and huge donations. Yes, that happens, but more regularly, people are just every year, they're saying, at the end of the year, I know I support Land for Good. I'm going to send them that check. Or every month, again, I'm going to donate $20, $50 a month and just have that go to them. So charitable giving, planned giving, it's for everybody because there's no set amount there. You don't have to have buckets of money for it to make sense. It's completely at your comfort level. So I say don't just discount it right away if you think that's kind of not for me, because maybe we can set it up, or you can set it up in such a way that it still works. You get to fund all the wonderful projects for organizations like Land for Good, in a way that still, again, isn't going to impact your salary, impact your income. All right. So I will kind of get off my soapbox now a little bit, and just to say Land for Good's website has a whole bunch of information that is really great in terms of making monthly gifts, or saying I want to include money, or I want to donate money through a donor advised fund. I want to make a donation of land. I want to include Land for Good in my estate plan. How do I do that? So there's so much information that's available on the website. So I would say that's a really great place to start. And I included the link here for Land for Good's website. But this is now where I get to open up the floor and say, if anybody has any questions, please feel free to fire away.
I had some questions.
Sure.
If you have an irrevocable trust, and I am your trustee, and you have in the trust, that you would like, me to give $20,000 to Land for Good, but you no longer actually have control over that. And I was like, I don't want to give that 20,000 for Land for Good. I actually want to give it to myself. Do I have that right as the trustee of an irrevocable, or do I have to follow through?
So a trustee really doesn't have discretion. They're bound by the rules of the trust. So if the trust says when I die, $20,000 has to go to Land for Good, you have to cut that check to $20,000 for Land for Good. And to the extent you decide, the heck with it, I'm just going to buy myself a really nice cruise and go off to the Bahamas this year. That's why also the probate courts exist. So the beneficiaries of the trust, or other folks who have an inkling that something's not right here, can always bring it into the courts and force you to account for what happened to the funds. A lot of times, too, with probate matters, when the courts get involved, and sometimes with these irrevocable trusts, kind of an insurance policy, and even though it's not technically an insurance policy, it's actually called a bond, will force the fiduciary to get this bond to say, just in case I run off with the money, I can still make the trust whole. So a lot of times we could talk to folks about, well, one, pick a trustee that's really trustworthy. But if you wanted some additional protection, you might want to also talk about having the trustee obtain a bond to make sure that exactly in the case where you said, I just don't want to do it this year, and they run off and take the money still comes back ultimately to the trust.
And then a final follow-up question. How does that pair with, my understanding was that I want to get the farm out of my possession so I avoid the Medicaid look back or whatnot. And so I dump it into an irrevocable trust. And you and Rachel are, I don't know if you're the trustees or the beneficiaries, I guess the trustees. And so that means that I have to trust you because you can do whatever you want because I no longer possess it. I just have right of use for my life. And you could be like, yeah, we're selling the farm now. We're not keeping it. This is our choice. You don't actually have a vote in this.
So that it still all comes back to how you've written up the trust.
Okay.
Because yes, there is the loss of control, absolutely. But before you lose control, you say, but when I put my assets in, like the farm in, here's what the trustee is and isn't allowed to do. So
Excellent.
you can explicitly say they're not allowed to sell the farm until after I've passed away. Or if they want to sell it, they first have to offer it for sale to my kids or to my family members. And you know what? They get to buy it at 50% of what it's worth. Or to specifically say, yes, you can sell, but only in dire circumstances where there's just not money to pay the property taxes, or kind of these big unforeseen circumstances have come up. So you can still put a lot of strings on it. So even though at that point, yes, you're right, you all you have now is the right to live there, but you've still restricted what the trustees are allowed to do.
That's super helpful. I appreciate that. That's the good news. The bad news is that Rachel's family and my family are not going on the cruise anymore. But
Well, I'm sorry to hear about that, but all right. Were there any other questions?
Yeah, I have a piggyback question on Seth's first question. So the implications of setting up this irrevocable trust for which the trustees are responsible, does that imply that the person setting it up should alert the beneficiaries so that those people know, hey, by the way, I set this trust up in the event of my death, here's what it should look like. Just in case that doesn't happen, you at least are informed. Like, would that be considered sort of a wise practice for people to do?
You can, and actually, under certain states have laws that require notice to the beneficiaries under certain circumstances. So in Connecticut, we've actually adopted what's called the Uniform Trust Code that has really specific notice requirements specifically to irrevocable trusts. You have to notify beneficiaries that they are a beneficiary. You have to provide them with accountings of what's happening with the trust assets periodically. So it's not necessarily just, I better tell people about it. The trustee may actually be required to do it anyways, depending on what the state law is. But yeah, I'd say particularly if a lot of times with these irrevocable trusts, even if they're not full beneficiaries, it tends to be a lot of family members or at least partial beneficiaries to say, when I pass, it's some split between the kids and the charities and everybody else. So to include the kids or those beneficiaries as kind of part of the plan, I think is just generally helpful to say, here's what I've set up. Here's kind of why I did it. So if you have any questions, a lot of times too, sometimes those beneficiaries are the trustees. So it's helpful to include them in that discussion, kind of let them know what they do and do not need to do. But yeah, I would say just notice is always a good thing. Just because it does put those additional safeguards in place once people are aware that it exists. The downside is that now everybody knows it exists. So if you think somebody goes, oh gosh, now that I'm a beneficiary, I'm going to start banging down Rachel's door every day because I know there's money in there and I want my money. So, but again, there's always going to be notice. You have to give certain levels of notice to beneficiaries under an irrevocable trust, but being proactive is good, but also maybe potentially being a little bit careful about how much information you're giving.
I have another question, if it's okay.
Yep.
So, say you mentioned a few times, if I die, my spouse is my primary beneficiary for my retirement account, but then the secondary beneficiary is these three charities. Do you need the cooperation of the primary beneficiary? Or can they, since they will receive those assets when you pass and they're still living, um, I assume they're doing whatever they would like to do with those assets. And so then do they need to cooperate in passing that on after their death? Or is there some legal mechanism that ensures that it has to happen?
So there's certain assets where kind of at least initially you have to name the spouse as the primary beneficiary, or if you're not going to name them, you have to get their consent to not name them, and it's pretty much qualified retirement account. So it's the 401(k)s and such. But in your example where you say, but I did name my spouse first, it just so happens my spouse passed away before I did. So now it's bypassing my spouse and it's going to my three charities. In that instance, there's nothing additional your spouse needs to sign off on because you did name them as the primary beneficiary. They just didn't happen to survive you. With other types of accounts, so your regular run-of-the-mill life insurance policies, investment accounts, cash accounts, you're free to name whomever you want as beneficiaries on those. There's no requirement that spouse be the primary. So you can just say maybe those accounts go directly to Land for Good, or maybe it's still, I name my spouse first, name those second, and there's still no notification kind of or consent that you need to get for the spouse. I would say maybe the more complicated part of it is to say, well, I pass away and it said my spouse first, and now it did go to my spouse. Now it's almost a brand new account in my spouse's name, and my spouse now has to name beneficiaries on that account. So I would say if it's really supposed to be a coordinated plan to say, well, regardless of whether I pass first or you pass first, when we're both gone, here's where we both want to see the money end up. I think you guys need to have a meeting of the minds to know that, okay, my husband passed, I got his IRA. He really said when he passed away, he wanted that to go to Land for Good and he wanted that to go to the Humane Society and these charities that he likes to support. So you need to make sure that, now that I have it, I know what those plans were. So I can go now and name them as beneficiaries on the account to say, yes, it did go to me first, but we both agreed this is where it's supposed to ultimately end up. All right, any more questions? All right, then Rachel, I guess I can kick it back to you.
I
Sure.
will actually ask one more question if we have
Sure.
time.
Good. Yeah.
So the donor account, so I would set that up with Fidelity, Edward Jones, whomever.
Mhm.
And then I would either, and I could choose to populate that whenever it best fit my tax situation. So if know I'm going to give, I can either give upon my passing, or I can give in a year where I didn't know I'd get consulting work and my required minimum distribution was whatever. And so that becomes a tool to be able to use in that way too, then.
Yeah, so I think the simple answer is you can fund those donor advised funds at any point. So I actually recently, as part of an estate plan, I set it up to say that a donor advised fund kind of will be created upon my passing and funded through this money passing under my will. So it doesn't exist now, but the executor, the trustee is going to create it when I pass and fund it then. Or to say, this year I just got a whole bunch more income that I wasn't expecting to get. So I'm just going to fund that now and then it's going to sit there and then, you get to continue to make distributions now in addition to after you pass. So it's entirely up to you.
Love it. That's excellent. Thank you so much. Appreciate it.
Thanks, Allison. This has really been lovely. And thanks to everyone who joined. Really appreciate your time on this. Um, Allison, if additional questions come up, can folks reach out to you, or would you rather filter those questions through Land for Good?
So I would say have the questions probably go to Land for Good first. And if
Sure.
there's certain questions that need my expertise, I'm happy to reach out then as well.
Excellent. Thank you very much.